Public health monitors violence, and one of the reasons that we monitor violence is we have a state health improvement plan. Now, what I'm talking about is collecting data from sources such as medical examiners, law enforcement, death certificates, hospitalization records, emergency department records, behavioral health surveys, so that we can sort of monitor and understand the types of injury and violence that have impacts on both individuals and families and communities as well. Here's a picture of the kind of data that we collect. One of the things that's most interesting when people start thinking about firearm violence in the state of Oregon is, wow, the impact is really in later ages, and it really is among males. And if you look at the distribution among people by race, non-Hispanic whites, non-Hispanic African Americans, and non-Hispanic Native Americans and Asian and Pacific Islanders. So this violent death reporting system is now working in 40 states. And after mostly the Sandy Hook shootings occurred, there was a big push in Congress to increase the appropriation for a systematic collection of data on firearm violence across the U.S. So if you go to our website, you'll also be able to look at trends over time. So this is a picture of the count of the total firearm deaths. In the bottom one, you're seeing the count of suicide deaths. The total count and the suicide deaths look very, very similar, because most of the deaths by firearms in Oregon are due to suicide. You can also, on this new website, call up county maps. And so this map is called, what we say in public health lingo, a heat map. So the places where the rates are highest are the darkest, and the places where the rates are lowest are the lightest. So this is total firearm deaths, 2005 to 2014. Next slide, please. And this one is rates for 2005 to 2014 for suicide. And as you can see, the counties that have the most heat, or the darkest colors, are counties where the people are living in great isolation. This idea of isolation is also connected to issues around access to care and access to services and social supports and depressed economies. So travel and transportation. So when people ask me why people die by suicide more often or at greater rates in very small counties that are far-flung, I go, well, there's lots of reasons. So you also have the ability on this to look at firearm deaths by intent. So we talk about, in medical lingo, by our medical examiners and police officers, suicide is an intent. Homicide is an intent. A legal intervention death is when an officer shoots someone in the line of duty. There are unintentional firearm injuries, where most often a child shoots someone. So among the different intentions in Oregon, it's really easy to see that almost 77% of our deaths are suicide. You can also use this map in the next slide to look at, if you want to see the type of firearm that was used by intent. And you can see across intents, homicide and suicide in the state of Oregon, we're really talking about handguns. So I have 3 slides that talk about policy. This one says, with respect to suicide, it may help for states to legislate waiting times. Might be most feasible to ensure that acutely suicidal people are deprived of ready access. Next slide. This slide talks about 40% of households in Oregon had firearms in 2002 from the latest study on that. That means 58,000 children lived in households with loaded firearms, 26,000 unlocked and loaded. Next slide. There's a consortium for risk-based firearm policy that has crafted state and federal policy recommendations. The first one is that gun violence could be reduced by time and limited restrictions on gun access by persons based on evidence of their individual risk. That a history of any kind of violence, particularly with criminal justice involvement, is a better predictor of future gun violence than is the broad category of person diagnosed with serious mental illness. And finally, that expanding gun disqualification based on evidence of risk must achieve balance with policies that offer a timely opportunity for clinically informed restoration of rights.
So as folks consider the statistics that we just saw, whether it's, state officials that are developing or implementing policy, or whether it's advocates or concerned citizens that are going to advocate for changes to the laws, I should say, regulating guns, one thing they have to keep in mind is the potential restrictions, the constitutional restrictions laid out in the Second Amendment. I would encourage folks to think, as we have this conversation, about the Second Amendment in two halves. So the first half, a well-regulated militia being necessary to the security of a free state. And then the second half, the right of the people to keep and bear arms shall not be infringed. There are two competing and fundamentally different understandings of the Second Amendment. One is that there is a right to keep and bear arms in connection with state-organized militia service. If that is the correct understanding and interpretation of the Constitution, then state and local officials and advocates don't have to worry much about the constitutional limitations on laws, because the militia that was being conceived of at the time of the framing of the Constitution was all able-bodied men in a state who could be called up into military service, and this was relevant when we didn't have standing armies. Of course, today in the United States, we have a standing Army, Navy, Air Force, and Marines, and they have capacities that far outstrip any capacity that state militias that could be called up by the state or under other constitutional provisions, the federal government. Our standing armies now far outstrip those capacities, so we don't have the militia anymore. So if the right is just the right to bear arms in connection with state-organized militia service, it's not much of a right, not much of a limitation on the ability of policymakers to make law. And for over 200 years, the Supreme Court never interpreted the Second Amendment the more broad way. And that more broad way in the competing interpretation is that it protects an individual right to keep and bear arms unconnected to militia service for other lawful purposes, the most notable being the right to self-defense. For over 200 years, the court never interpreted it that way. So the legal establishment, for what it's worth, had a pretty settled expectation that the first interpretation was the right one. It's only a right in connection with militia service. It's not a right for other purposes for individuals to keep and bear arms. There were some academics, both liberal and conservative, who were like, the language is pretty strong about there being a right, and maybe we should spend a little more time on this, and it's worth more study. And that position, and obviously there were advocates, the National Rifle Association only being one of many advocates for the broader interpretation, that kept pressing the case. And eventually in 2008, so less than a decade ago, in 2008, the Supreme Court took up a case, and this was sort of the ideal case if you were going to try a first case to get the broader interpretation accepted by the court. The District of Columbia had a very strong law prohibiting possession of guns in many contexts, and including possession of handguns in the home. If ever the court's going to recognize an individual right unconnected with militia service, it's probably going to be in the home. And the court split 5-4 on this fundamental question. 5 members of the court, the majority, held that actually the Second Amendment provides an individual right to keep and bear arms for any lawful purpose, including self-defense. But here's the thing. The Heller case recognizes this individual right, but it treated it as a very easy case. It basically says if ever the individual right is protected, it's in the home to possess a handgun, which is the most common weapon, firearm in the United States. But the court says, of course, like all other constitutional rights, there are limits on this constitutional right. There are limits, and the court says we don't mean to cast doubt on long-standing limits that have been in the law. This has left lower courts somewhat at sea in figuring out, okay, now we have this new individual right, well, I should say newly recognized individual right by the Supreme Court to keep and bear arms unconnected to militia service. There's lots of laws on the books, proposed laws on the books. Do they violate the Second Amendment? All of which is to say that there is a lot to be determined in this area. We are less than a decade into the Supreme Court teasing out the details of its Second Amendment jurisprudence, and that, I think, leaves both policymakers and advocates in a somewhat tough spot because we don't know exactly what the courts will and won't uphold going forward.
What drove me to speak up for more sensible gun laws and was a motivator for forming Gun Owners for Responsible Ownership. We didn't see anybody in the middle on that aspect, and we wanted to lend a voice to gun owners who had middle ground and weren't extreme on the right. My brother-in-law was one of the shooting victims at the Clackamas Town Center Mall. Shortly before Steve was killed, a family member sent me these posts. You can see in the lower left, there's a young man pointing a 9mm Glock at the screen and bragging about getting a concealed handgun license in 2 weeks, and says, "Who wants to get shot?" On the lower right, he's got a few more comments and is again bragging about getting a Glock. And one thing I will say, I've gone through the class to get a CHL in Oregon. Oregon has a pretty low threshold. There's no live firearm training. You don't have to have a gun at the class. It is basically a matter of filling out some paperwork, sending it in, and paying your $50, and you've got a license good for 4 years. The main point of sharing this incident is to illustrate how little power we felt we had to intervene with these threats that were made to a family member of ours. Both in the currently in the Oregon legislature and nationally, there are reciprocity bills that require states to honor concealed handgun licenses from other states. The national bill would require that the state of Oregon honor a concealed handgun license from every other state. Passage of the concealed carry reciprocity bills, either in Oregon legislature at the federal level, in my mind, will put our families and our communities, and especially our law enforcement officers, at greater risk. Whether or not you own a gun or have ever been threatened by someone with a gun, I hope sharing my personal experience will prompt you to look closer at these proposed reciprocity bills and ask your legislators to oppose them, or ask your legislator to justify why we need such reciprocity laws. Cases of defensive use of a concealed handgun are very rare. I mean, they are hardly measurable. This is the other incident that really drove me to speak out on gun violence. For those that don't know, these are photos taken the afternoon of the shooting at the Clackamas Town Center Mall, inside the mall, in the food court area. What you see is chaos. Overturned chairs, personal belongings left everywhere. This is some of the damage in the mall due to the gunfire from the Stag 15, which is an assault-style weapon. In this picture, you'll see this is a Stag 15 assault rifle. And this was the actual gun used in the shooting. The gun owner purchased the gun legally. The shooter took the gun from the gun owner the morning of the shooting because the gun was unlocked and loaded. The shooter had also purchased 4 high-capacity magazines and 120 rounds of ammunition in the 2 days prior to the shooting. So this was a premeditated event, but the gun owner had no knowledge and had nothing to do with the shooting itself. We found out Oregon has no safe storage gun law, and Oregon has no law that requires a gun owner to report a stolen gun. The other part of our group, our message, is child access prevention, and the idea of these cap laws is ideally to ultimately change the behavior of gun owners to store their weapons securely. I think it's very comparable to our drunk driving laws. That's what we're trying to do with gun ownership. Change the cultural thoughts and the perspective on it, and I think take it back to what it used to be. So, real quickly, what you see here on the screen are, for less than $10, each of these items will lock up a gun. When you buy a new gun, they come with a gun lock. One of those types. The first rifle I bought for my son, I bought a week before Steve was killed. Every new gun comes with a gun lock. There is no reason not to use one. They're in the box. It is a conscious decision not to use one.
In the year 2000, we here in Oregon voted to create a background check on the sale of every gun that was sold at a gun show. So federal law requires that guns that are sold by federally licensed firearms dealers in a store, are subject to a background check. And here in Oregon, we decided that we would like to extend that prohibition on background check-free gun sales to guns sold at gun shows as well. So we fast forward to 2015, and the Oregon legislature in that session worked very hard and passed a law creating a background check on the sale of every gun in Oregon. So where we are today in 2017, we're back obviously for a full legislative session this year. And at the Oregon Alliance for Gun Safety, our agenda has 3 points this year. So maybe I'll start in the middle and talk about strengthening Oregon's background check laws. Oregon is now it's a great number of states that require a background check before the sale of a gun, either at a gun show or through a private transaction or both. And what we are trying to do with this bill is strengthen that law. So the first element would be to close what we call the Charleston loophole. Here in Oregon, we run our background check system is managed by the Oregon State Police. We manage this process locally. And if a background check if someone attempts to buy a gun, and the background check has not been completed by the Oregon State Police in 3 business days, the seller of the gun has the right to transfer the gun to that buyer without a completed background check. So the vast majority of background checks in Oregon are completed in minutes, even seconds. It's actually pretty straightforward. It takes longer to fill out the piece of paper than it does to run the background check transaction for 95+% of gun purchases. But in a small number of transactions, it takes longer than a few minutes and oftentimes takes longer than 3 days. And what we would like is for the process to complete. We don't feel like there should be some third category of gun buyer who gets to skirt the law, skirt the process just because their background check hasn't been completed in a small, in that brief window of time. So the Charleston loophole is named for the shooter, Dylan Roof in Charleston, who was able to purchase a handgun despite being a criminal and a prohibited person because his background check was not completed within the required 3 days. Okay, so on to, let's go back a slide and talk about child access prevention. So Paul gave us a nice introduction to this. Oregon is a state that has no current child access prevention laws. These laws hold gun owners responsible if a child or a minor obtains unsupervised access to a firearm. So as you can see, there are some states with high percentages of gun owners that have decided that it is a crime to leave a gun unsecured in the home of a child. The estimate is that up to 26,000 Oregon children live in a home today that has an unlocked and loaded gun. And the national statistic is at this point about 10 years old, but found that nearly 2 million children under the age of 18 live in a home with an unsecured and loaded gun. Nationally, about half of unintentional firearm deaths are due to children accessing a loaded and improperly secured gun. Okay, so let's move on to the third bill that's on our agenda for 2017. The Extreme Risk Protection Order is about empowering families. Families tend to know when an individual is at risk of violence or suicide. And what the Extreme Risk Protection Order does is take that concept, which allows a family member who recognizes a risk to take action before a tragedy happens.